I hope everyone is everyone continues to cope with the newly transitions of this whole COVID-19 stuff. I hope everyone's finding different and unique ways to cope and to make sure that they continue to practice wellness exercises and grounding activities only to be safe and remain healthy and spiritually uplifted. Before we start tonight's event, I want to share some group guidelines just so that we can go through tonight in the most efficient way possible. First and foremost, as mentioned and as always mentioned in our previous sessions, is that we have a zero tolerance rule for disrespect, disrespectful remarks that promote hate speech and threats, etc. That being said, if things do get carried away, we may result into ushering people out of tonight's panel discussion. However, we do promote a brave and safe space, meaning we don't want anyone to be censored or we don't encourage censorship. However, your speech must remain in respect to another person's thoughts, opinions, and experiences. Second, we ask that people please remain on mute unless you are presenting. This is for the respect for those who are speaking and to you all who are listening. That being said, we know that some people may be busy as they're listening through this session, and we just want you to be aware that your backgrounds could be kind of distracting. Just always remain on mute. If you do end up coming off of mute, for whatever reason, the host of tonight does have the control to mute you. So don't feel any way if you come off of mute or such and such. The mute button is located on the bottom left corner of your screen. There should be a red strike button, a red strikeout line if you are on mute. If you're not on mute, then you would see like a little green little thing going up and down. We do ask that people use the chat option. Everyone has open access to the chat option. If you don't get the chance to speak or if you do have a burning question, we ask that you just use the chat option. Think Twice staff will be there all night monitoring the chats, monitoring for any comments, concerns, questions, or even updates. You can message myself personally. I am Jafar. You could also message Tasha. I believe Tasha's name on here is Natasha Think Twice. And then we also have Emerly. It's Emerile. That's another Think Twice staff. So we do encourage you guys to use the chat if you don't get the chance to speak. At the end, there will be also a question period where we'll ask the questions that were in the chat for the panelists that are here to share with us today. We want everyone to know that that the seminar will be recorded. It actually is recorded right now. That being said, there is a feature on the bottom left corner. Also, it's right beside the mute button that allows you to stop your video and to start your video, which basically puts your face on the camera for the panelists to see, or you could take yourself off. That being said, we do ask if you are going to share your camera or you're going to share your face on the camera, we do ask that it's respectful or you remain in tasteful manner. Again, not promoting any disrespectful images or disrespectful manners. What else do we have here? Again, if you'd like to share, or even if you'd like to share tonight's discussion, we do ask you to invite everybody that you know and post on your social medias, text your friends, text your family members. There is a sharing option. A sharing option for one, if you're on a laptop, is at the upper left-hand corner. You'll see like the eye icon. You just click on that and it says copy URL. You can send it out to everybody. For the phones, it actually says under share. You could share via any way possible or on the options that it's given. What else is there? Again, if you have any questions, we do encourage you guys to use the chat and message us privately. All night we'll be here recording the messages and the questions. So don't worry if your question or concern doesn't get addressed right away. It will get addressed by the end of tonight. Remember, tonight is all about networking, educating, and creating awareness. Tonight, it's all about positive vibes. I also want to acknowledge for those who are celebrating or acknowledging Ramadan Mubarak to those who are acknowledging the holy days. And I now give it back to West Diamond.
Hi, sorry, good evening, everybody. My name is Natasha. As Jafari mentioned, my name is Natasha Think Twice. If you have any questions or concerns, you could just go in the chat section and we will be monitoring all the questions. And I hope you enjoy the panel today.
Hi, this is Emerly also. I will be helping monitor the chat. So that's Emerlie. You can also message me or just message in the group if you have any questions. Thanks.
All right, thanks, guys. I just want to introduce us. We're Think Twice, founded in 2006. We assist in eliminating the impact of inequality and social injustice amongst racialized young people in the criminal justice system. Our initiatives assist individuals to think twice and unlearn negative behaviors. Some of our initiatives include leadership programming in federal institutions, such as the Kings to Kings Project, that provides workshops to youth in neighborhoods that experience gun violence and incarceration. The Trap documentary, which is a video that documents 8 people who are currently serving life sentences. And the Dying to Live production, which is a play we produce, which details mental health awareness and gun prevention intervention initiatives. Why we're doing this? To spread awareness throughout the community, to build a platform so we can have real dialogue with real people, formulate a plan of action, advise those with lived experience, and receive advice from those, and support each other. Zia?
Good evening, everyone. So just to recap, our first meeting had a focus on the conditions of COVID-19 within the correctional facilities. We focused mainly on the self-detention center because there were some issues in the cell that we were bringing light to. We had a petition that we sent out. Based off of the petition, that's why we started the state of corrections. Some of the issues that we were facing in the self-detention was there was a lack of hygiene and sanitation and preventions for COVID-19. With a focus, we were asking for masks for guards and masks for inmates. Inmates had to buy soap and cleaning products. So if they didn't have canteen, they weren't able to purchase the soap. The excessive lockdowns, 22 hours a day. Sometimes units were not able to take a shower for 3 days. So based on some of those issues, we were really speaking about the provincial system and provincial jails. But along this little journey here, there are also other issues in different institutions as well as federal. So this opened the door for some of the issues within corrections that need to be addressed. So as I said, the first series that we had, the first panel that we had was with a focus on provincial. The second part that we had was last week, and we focused on a young man who was denied medical care in Maplehurst last year, and he passed, Sean Spalding. So we were really speaking about medical care within corrections. And there were some questions and comments that came up after reading them yesterday that we decided to address today. So today we're going back to the first initiative, which was really talking about COVID-19 within the institutions. As mentioned before, there will be a parole lawyer that's speaking, criminal defense lawyer that will be speaking as well. There is the founder of Recovery Science, Ankle Monitor Company. I want people to ask questions. Families, ask your questions about parole, early release, bail in these times, what a good plan looks like, a good release plan looks like, house arrest, ankle monitors, whatever questions you have, please make sure you write it on the board, and we will actually ask each panelist 3 questions after each one is finished, and then at the end we'll have a question and answer period. Also, we'll be speaking with a young lady whose brother is also in an institution, and he tested positive for COVID-19. So some of his story and some of the issues that this family faced and this individual is facing right now. And there's also a young man who is incarcerated. He was arrested during the COVID-19 period and also released on bail. So he'll be speaking about some of the issues that positive and negative as well. We're not here to bash anyone. If there's an institution that is moving correctly, we will be the first to acknowledge that. We've spoken a lot about the difference between federal and provincial. So I'm not saying federal is moving correctly at all. What I am saying is some of the institutions that we deal with in federal are actually, I could say that I'm proud of them. Beaver Creek Institution being one. So we talked about the differences between the South Detention Center and the provincial jails versus the federal, which is with one, we had an inmate call in from Beaver Creek. So for instance, inmates are being, they received a job to clean. All personal hygienes are free. Soap is free. Cleaning products are free. Guards had masks and inmates now have masks. Just to name a few things, and that shows a difference in provincial, where inmates don't have masks. Inmates still have to buy their products. So these are some of the issues that we're talking about today. And the importance, and to really understand that, you know, in some of these institutions, when you're caging human beings in a cage for 23 hours a day, 22 hours lockdown, excessive lockdowns, I'm not sure what the community expects to become of these people. That breaks people. Right? If you don't have a strong, and I mean a strong faith, that will break you. So we have a whole lot of issues within the criminal justice system, mental health issues. And I personally believe that oppression leads to poverty, which leads to gun and gang violence, which leads to survival of the fittest, which leads to incarceration and back to financial gain for the criminal justice system. But as I said today, we're gonna have a focus on COVID-19 in corrections. So some of the comments I wanted to mention real quick from last week. So as I said, we spoke about Sean Spalding, who was denied medical care in Maplehurst Institution last March, and he died as a result. We spoke with his sister. We spoke with a young man who was on his range. I read through some of the comments, and there's a few that I wanted to highlight. Someone said it's worse in federal, and in the Bay right now, there's no doctor. For months, I've emailed the commissioner, and they said that what they said is basically untrue. Someone else said, my fiance is in federal. My fiance was in federal and is out. After all the requests we put in, he still hasn't seen a doctor or a dentist. Another person said, I've heard many stories like this from my son in federal. While in provincial, he had an infection that got so infected without treatment, we were worried. It went septic. Like mentioned, it's risky to advocate for fear of punishment. I have many stories like this from his time inside. And there was one of the chaplains that was listening last week, and the chaplain said, if you could tell me which institution, I might be able to help through chaplaincy. So those are some of the things that stood out to me, and I wanted to mention them, and I want to have a conversation about that as well. We're going to turn to the panelists now. So this is a young man that was arrested in the COVID-19 time and also let out on bail. So if you could just introduce you, my friend.
Hello? Can everybody hear me?
Yeah, we can.
Okay, yeah, my name is Alistair. I was arrested for driving offense during the COVID-19 time, and what I can say is that all the guards didn't really have masks, but the protocol called for it. So it was weird, but on the ranges itself, it's already really structured. So it was even more structured. Which is kind of, depending on what side of the fence you're on, it may be annoyingly structured.
Right.
The
Yes.
nurses are, they're really stringent. They're ensuring this, and I was on the range that was, it was an isolation range. So basically, you have to be on that range for 14 days, and
Okay.
it's from the, yeah. Go ahead.
Before you start, can you just, I know we do this every week, but can you just tell us the difference between federal and provincial? What is the difference between a provincial jail and a federal prison?
Provincial is where you're gonna be is before you're convicted,
Okay.
and federal is after you're convicted. And to be federal, you have to receive a sentence of 2 years plus a day, and anything under that, you're gonna be in provincial.
Okay.
But in provincial, it's everything is essentially max. It's a max institution. That's the thing about provincial. Federal, you can go from max to minimum.
Explain that to us. Explain that to the people who don't understand.
Um, well, in the provincial, it's going to be straight a lot of static barriers. The bars, what you see on TV, and essentially, depending on where you're housed, but you're going to be in a cell like that. But in federal, there's tiers. Like it starts from that level, and you move down as you graduate for good behavior and whatnot. And if part of your correctional plan, so then you have to go to different levels. Not you don't have to, depending on what who the person is, but essentially that's how the system works. We go down, you graduate to different tiers, to a higher tier of safety level, right? In provincial, it's just one safety level, it's max. But you if you do provincial time, you usually do 2/3 of your time. In federal, you may not. You can do 1/6 depending on your crime. So it varies.
Okay. Can you tell us when you were arrested, just around the time frame, like what date?
Just about a month ago.
Okay. And what jail did you go to?
Maplehurst.
Okay. And now you can continue about what you were saying about Maplehurst and what were the conditions like? You said you were on quarantine for 2 weeks. Can you tell us about that?
No, I wasn't there for that long. I
Okay.
luckily was released, but yeah, it's basically if you say you go in on a Monday, you're gonna be there till the 2 month for 2 weeks. So if somebody comes in on Tuesday, they're gonna leave Tuesday. So it's like it depends on what day you come in. And if somebody came in on Monday, they can't associate with anybody that came on Tuesday or Wednesday or Thursday and so forth. And if somebody came in the day before you, you can't associate with them. So they made sure that everybody basically has to do that 14 days before they can associate with, I guess, the general population.
Okay. And I personally, I think that's great.
Yeah.
I'm glad to hear that.
The bad part is that if you're on a range and the whole range is packed up, right? Then the likeliness of getting out to have a shower and go to yard and becomes less and less chances because as the population on the range grows, right? So if you're there the first time, you can basically, you're the first person there, starting the 14 days, you can go outside. The minute somebody else comes, you have to split that time. When somebody else comes, you have to split that time, right? So if there's 10 people on the range, then you're basically splitting an hour each individual, 5 minutes. You know what I mean? If you get out, that's if they're not doing this or doing that. So in that part, in that sense, they're not really ensuring everybody has access to shower and or yard is not even probably not even on the table, right? So those little things are unfortunately xed out because of that. And I think maybe like developing a plan for those type of situations would be good.
Okay. And then the bail process. So you got bail?
Not really. I got released through the parole board.
Okay. Okay. All right, cool. And is there any message that you'd like to leave with the loved ones of people who are incarcerated, or young people who are incarcerated themselves?
I would say basically the trick to actually, getting out, being released effectively is psychology. Speak with the psychologist, whatever is going on, let them know. Because then you create and you humanize yourself. They don't look at us as humans. They look at us as just, bad people. But everybody has a story. So if you show your story, then it makes us more acceptable, because now we have a story. Like when we look at the news, they have the guy that he unfortunately murdered a bunch of people, but they give a story behind him. So now it kind of looks sympathetic. Oh, I don't understand. But for another person, maybe of a different ethnicity, they're gonna say, oh, he's just a savage criminal from day one. But you have to let them know your story and who you are, and it's not that, because they're not gonna understand us.
Okay.
So, obviously, things are things, and that your story means let your story, but not let anybody else's story. Let your story and what's going on in your mind and how you feel with certain things. That's what I mean.
Okay.
That would be my only advice. And I always believe in the Father.
Yes, yes. Well, thank you very much for sharing. Um,
You're welcome.
does anyone have, so we'll do a few questions for every panelist. Does anyone have any questions specifically for this young man? Write it on the board. Message board, are there any questions?
None so far.
Okay, we'll move on. If anyone has any questions, feel free to leave it on the board. The second panelist is a family member of a young man who's in custody and he tested positive for COVID-19. How are you, sister?
Hello, Zaya. I'm well, thank you. How are you?
I'm good, I'm good.
That's good.
So, can I ask you, how old is your brother? I think you're on mute.
Sorry, can you hear me now?
Yep, can you hear you?
Okay, can you just give me one moment? I want to take out my notes because I don't want to give any incorrect facts.
Sure.
My brother is 21 years old.
Okay. How long has he been incarcerated?
He's been incarcerated since August 2019.
Okay, when and how did you find out that he tested positive?
My mom had actually found out that he was positive. She found out on Monday, April the 27th. And I myself found out that he was positive the day after, Tuesday, April 28th.
And how did you find out?
My mom told me over the phone.
And how did your mom find out? Was it from your brother or was it someone from the institution?
She found out from him through a phone call, obviously.
Okay. And how has he been treated? How has he been treated? And please feel free to share your story. I heard about your story on Instagram and asked you to speak. So feel free to share your story.
Okay. Would it be too long for me to basically read some of my story from what I had posted on Instagram?
Sure, go ahead.
Okay, just one moment, please.
Off the top of your head, can you just tell us how many inmates have.
Okay. So, sorry, Tia, where's my notes, Mama? I apologize. I'm very new to this and I'm trying to.
That's all right.
On a separate screen. Okay, so, basically on March 17th, the government declared a national emergency, state of emergency, worldwide pandemic. And then on March 30th, inmates, my brother, who was at Brampton OCI, Brampton, Ontario Correctional Institution, inmates there on March 30th, so 2 weeks after the pandemic was stated, they were stating their concerns about COVID to their social workers. Their concerns were brushed off, basically. Another 2 weeks passed, April 15th, and an outbreak was then declared after 3 guards had tested positive. 3 days later, April 18th, an inmate tested positive. So this is a month after the pandemic was stated through the news, a month after, and still no changes at all were made in the Brampton OCI. Everything was just going on, carrying on normally. On April the 18th, all the inmates were then tested. After the 3 guards were positive and 1 inmate was positive, they then tested all the inmates for the first time. The meals were then being served on each unit instead of in the dining hall. So it was 20 to 25 people eating meals together at a time. On that date, April 18th, some inmates started to be transferred to Toronto South Detention Center. At that point, no enhanced cleaning, sanitizing procedures were being done on the units, just inmates doing their regular cleaning duties. Nothing additional was being done. There was no change to the sleeping arrangements. It was still 5 to 6 people dorm style. And the next day, April 19th, more inmates were then transferred out. Late night news report on April the 19th that Brampton OCI would be getting shut down and all the inmates would be transferred to Toronto South Detention Center. On April the 20th, all the inmates were given masks. And on April 22nd, my brother was able to call my mom from South Detention. So my brother was, I don't know exactly when he was transferred, but the inmates were transferred between the dates of April the 18th to April 20th. And then 2 days later, my brother was able to call my mom and update her. So he had been transferred for at least 2 to 4 days, and no one in our family knew until April 22nd. And then on April 24th, he received his test results 2 days after being transferred. We were notified, my mom was notified about the test results on April 27th, as I mentioned. So my brother found out he was COVID positive on the 24th, and it wasn't until 3 days later that he was able to express that to my mom. He had to basically deal with that all on his own for 3 days. And on April 27th, my mom said that he had wanted to apply for TAP, sorry, I'm not understanding the writing on this note here. Anyways, on May the 2nd, my brother was retested. And on May the 3rd, on May 2nd, he was retested. Basically, since finding out that he was positive, I know that there was roughly 110 inmates in total at Brampton OCI, and 79 of 110 were tested positive. That's basically the entire population.
Wow.
25 guards were tested positive. That's a total of basically like 110 people altogether tested positive, 25 of their own staff and 79 inmates.
What's the population of OCI? How many inmates are there in total?
There's 110 in total.
Wow. Okay.
I found these results.
Whoops, sorry, that's my phone. And they were transferred to the South Detention.
Yes, they were. Everybody, even if you weren't positive, you were still transferred.
So if people can look up on the screen, Bill 6 states that inmate transfers to other correctional facilities during a pandemic, transfer of inmates between correctional facilities should be discouraged. So I'm not sure why they transfer them to the South, and I don't believe the South was prepared, and I don't believe that they were ready for that anyways. But what's the condition that he's facing right now in the South?
Right now, in my opinion, I would put the word is disgusting. I'm disgusted. And to elaborate on it, all the inmates, positive and negative, are being kept in isolation. It's one person to a cell. They have absolutely nothing in their cells with them besides their bed. There's no television, no reading material, no entertainment, nothing to keep themselves occupied like any basic human needs to be occupied. They get 10 minutes every other day for a shower and 20 minutes on every one of the other days for a phone call. That was recently changed. My mom had updated me that she spoke to my brother today, and the update is that last week the shower changed from 10 minutes every 2 days to 30 minutes every 2 days, and the phone calls changed from 20 minutes every 2 days to 30 minutes every 2 days. However, today's phone call, my mom said, was 20 minutes. There was no explanation. So that just goes to show there's no consistency. There's no explanations. It's just whatever they say goes. And that's just what it is. So, yeah.
Yeah, that's crazy. It was my apologies. That wasn't Bill 6. That was the Toronto Public Health Pandemic Plan. A guide for correctional facilities is what we read from. Is there anything else you'd like to share with the public? Anything you'd like to share with families who have incarcerated people, or just as an awareness piece for the community?
To be honest, I'm sorry, but I don't have any words of encouragement to pass on right now, because I feel so broken in my spirit for what my brother is going through and for what other people are going through. And
of course,
I don't even know what to say to other people. Mila, stop it right now. Sorry, my dog was about to bark. But I do want to shed some light on what these type of situations, these type of conditions can do to someone. It's pretty obvious that it could drive someone crazy, being locked in a cell with nothing to do, getting a shower once every 2 days, getting to talk to somebody about your emotions, your thoughts once every 2 days. I mean, first you find out that you're tested positive for an illness that could very well potentially kill you, an illness that's already killed so many others. And then they just shove you into a box to deal with it all by yourself. My brother is only 21 years old. You know, there's any 21-year-old I know is still young-minded to a certain extent. You haven't experienced what you need to experience in life to be at a fully mature state, to be able to handle such a traumatic situation completely on your own. And there's no mental workers going in to check on these individuals. They're not able to even communicate with each other, being able to relate to one another, nothing. Why can't these individuals socialize with each other at a safe distance the same way everyone else out here is able to? Why are they being punished, put in a punishing situation like isolation, something where they send people when they misbehave? These people have done nothing wrong. They asked to be tested way before all of this, when this just started. They were refused. And because people didn't want to do their jobs and people didn't want to treat them like humans, basically everyone there got sick, including their own staff. These people don't even care about their own staff, much less.
That's right.
And, you know, this can drive a person crazy. As you said, and I wasn't aware until you said it, someone committed suicide in Maplehurst. And guess what? The system had to pay back because it's wrong. And it's like, it's just the same story happening all over again, because this can easily drive someone to commit suicide or to lash out or to start bad behavior, which they hadn't done before, because they're pushed to do these things. And my brother, one day he's doing fine, he's optimistic, he's very encouraged by the fact that we're holding these meetings and whatnot. And then the next day, like today, for example, my mom found out that he's not coping well. It's the complete opposite of what he was 2 days ago.
That's right. Yep.
Punching walls, he's pushing his soap bar in and out underneath his prison bars, because he's being treated like an animal. So that's what he's starting to behave like, because that's what he's being treated like.
Yeah.
He's losing his mind, and it's not his fault. It's the system's fault, and it's not fair. He's a human being, and I'm very upset right now. I'm very emotional. It's disgusting.
Well, we thank you so much for sharing.
No, that's what's going on, and thank you for giving me the time to share the story.
Most definitely. Is there message board? Is there any questions? We'll take 3.
Yes, actually, we have the mother of the young male. Alicia, I believe it's your mother.
Yes, my mom, Tanya.
Her name is Tanya. Tanya would like to speak. Tanya, if we could unmute Tanya.
Mommy, you have to unmute yourself, I think.
Okay, hi.
Yeah, there she is. She's off mute now.
Hi, I'm Alicia's mom, and my son is the one she's talking about. And I just want to reiterate how angry we are and how concerned I am for my son, for the inmates. They're failed by the Ministry of the Attorney General. They failed their own staff. They failed the inmates. And I want to know who's going to pay the consequence for that. My son was paying his consequence, okay? I'm very old school. He was paying his consequence, but who's going to pay the consequence for putting him in this position? Because the rest of society prepared for a pandemic. Why didn't the Ministry of the Attorney General prepare for a pandemic in an institutional setting? Anyone with common sense knows if there's a storm coming, you buy batteries, you buy candles, you buy everything else. What was their plan? What was their plan?
I agree.
Okay, my son is not doing well. I have 20 minutes every 2 days to encourage him, to read him some scripture, to help him plan his goals for his future, to read him encouraging messages. And then what? What happens the next day? You know? Yesterday, he was doing okay. He was doing okay. Then I found out today, yesterday was not good. I felt off all day. I felt something was wrong. And he said yesterday was difficult. He was hitting the wall. He was banging the door. But that would probably be a normal reaction after 14 days and thinking you're going to be out of isolation soon, just to find out you're being retested and you're not going to be out of isolation until at least 14 days after a negative result comes back.
Yeah.
You know?
Yeah. If you look on the screen, people, Bill 6, it says the minister's function. C is circled. Providing services to ensure the safe and humane custody and care of inmates. I think this is very important because these conditions are inhumane.
It is.
And if you go down to J, providing information to the public respecting the operation of individual correctional institutions and the correctional system as a whole. So the lack of transparency, that's an issue. And this is Bill 6. I mean, we're talking about people that are in jail because they broke the law. Well, the law, this is what the law states. So it's okay for an individual to, it's not okay for an individual to break the law, but then it's okay for the system to break the law. So these are some of the issues that we're touching on. Are there any questions for the family of this young man who is in custody and has COVID-19? Jafar, are there any messages on the message board?
We have a statement or a comment from Andrea Page. She says, I have been saying this for, well, first she said, this is the furthest thing from restorative justice. I have been saying this for years. The key shift is to demand corrections to become trauma-informed. I am heartbroken to hear this story.
Thanks.
Thank you. And we want to think twice, and the audience wants to thank you both for sharing, and continue to share and to allow people to become aware of what's going on. And we're going to go to the criminal defense lawyer, Mr. Alawi. Are you on, Mr. Alawi?
Good evening. Yes, I am.
Good evening. Good evening. Can you introduce yourself, please?
Yeah. So my name is Idrus Alawi. I'm a criminal defense lawyer. I've been practicing as one for the last about 8 or 9 years now. I take on a lot of cases throughout the GTA, and I've just been doing a fair bit of work over the last month or so, just trying to assist clients who were in custody to obtain bail.
Welcome, and thank you so much for coming on this
Thank you for having me.
program. Can you tell us what your background is on a...
She doesn't have to pee. Good.
Sorry, I missed that.
Sorry, if you could just tell us about your background working provincially.
Sure. Yeah. So I've like I said, I've been practicing for the last 8 or 9 years. In terms of my practice, it's it goes throughout the GTA and a little bit beyond that. That's allowed me to kind of interact with a lot of clients and other criminal justice participants. When it comes to, it's also given me the opportunity to visit a lot of these provincial institutions. So Maplehurst, the South, the East, Central North, Central East, Hamilton, Wentworth. So it's been interesting, kind of seeing some of the responses to the COVID-19 pandemic from the various institutions, because I've come to learn that the approaches aren't necessarily uniform. I mean, each institution will kind of modify things for whatever reason relative to the other institutions. So it's made for interesting interactions, to say the least.
Can you tell us about the conditions inside the jails or prisons as relayed from your clients?
Sure. Yeah. I mean, so since about March 16th, my ability to kind of attend jails, let's say it's been, it's been reduced in a sense, but it's not even so much that it's been reduced, because technically professional visits are still ongoing, but it's been more, I don't know that's necessarily encouraged. So, for example, I can tell you the last time I was at the South was probably a month ago on April 8th. And that was to see a client who'd been arrested on the 3rd. And I think, I attended. It was a 10 a.m. visit. I got there, and, as I indicated, the jail was essentially closed down, save and except for professional visits and for chaplaincy services. And so I attend. There are two correctional officers seated by the front entrance. Come in, they take your temperature. Once you're you pass that, you move on to the next stage, which is where you walk up to the front counter, provide your ID, and then at that point I was told that I couldn't see my client, which was concerning for me, because he'd been arrested I think I indicated he'd been arrested 5 days earlier. I hadn't had a chance to speak to him. I wasn't even sure at that point if he'd received access to counsel upon his arrest. So obviously, my mind's thinking, well, were any statements made? So certainly thinking about some things for down the road in terms of potential trial strategy. And so when I asked, why is he, why am I not able to see him? I mean, I booked the appointment. It was confirmed, and I was told that, I actually got 3 or 4 different answers. One was he was displaying symptoms of COVID-19. That's what I was initially told. Then I was told, no, he wasn't displaying symptoms, but he was he had been exposed to somebody with who was displaying symptoms, and then it went from that to the person may have had it. So it was really difficult to decipher initially, but eventually I was told that he was placed under what's called the droplet protocol, and essentially they said that it's standard procedure. Anytime somebody comes either, well, in his case, somebody who comes into contact with somebody who's displaying symptoms, they're essentially quarantined. So that's what happened to him. He was quarantined for 14 days. As a result, I wasn't able to have that meeting. Well, I mean, I had it through a video call, but it wasn't. It was initially supposed to be behind glass, but again, because of the changes to, I guess his health status, they changed how they had that meeting. And so, I mean, that was one example of how things kind of played out at the South. I think I was at the Toronto East just maybe a week ago. Again, a different approach. I wasn't screened for anything at the East, but I think what they ended up doing at the East, though, or what they've been doing, is they essentially, since the general population visits are closed, or in other words, visits from family members and members of the public are closed. What they've done now is professional visitors attend that area. Everything's behind glass. There's nobody around me, so you just go in, you have your meeting, and you leave. And so, I mean, certainly it's made it difficult to really interact with clients, because again, apart from when I physically attend, you know, I can go days before I hear from a client, and again, you know, it speaks to some of those concerns that have already been raised around, you know, having to deal with this essentially in isolation, not really knowing what the situation is. I mean, like for example, with the young man at the South, I mean, you know, all that we've really been told is that he may have been exposed to somebody who was displaying some symptoms. But when I spoke to the healthcare manager, I was told he wasn't tested, and he wasn't going to be tested because he hadn't. He was asymptomatic, and so I think her words were it would be a waste of resources, right? So, which is concerning, because again, you know, I mean, you know, on a personal level for him, it's the not knowing, but then on a broader, you know, societal or community point of view, I mean, if he's got it and he's asymptomatic and he's interacting with people, I mean, all you're doing is just, you know, potentially spreading it to the population at the South, but also to the broader community. I mean, if he's interacting with correctional officers who in turn go back to their respective communities. So it's certainly a problem. And it's, I mean, it's the approach is, like I said, it hasn't been very consistent in terms of my experience with it. And it certainly doesn't go far enough.
Question: how are the courts operating right now?
So in terms of the courts are basically shut down, save and except for bail hearings. And when I say that, I'm strictly referring to the criminal courts. So unless it's a bail hearing or a guilty plea, the courts aren't really interacting, or rather, they're not really dealing with people's matters. If you had a set date, so if you were required to attend court to address your matter since March 16th, they've basically just en masse just adjourned everybody's matters 10 weeks from that particular date. For individuals who are going for bail, again, depending on the courthouse, there's some variation in terms of how they're doing it, but mostly it's telephone bails. Some courthouses have the capabilities to do video bail, but again, that's at least based on the bails that I've done. The only person who's up on video is my client, and then either the judge or the justice of the peace is the one who's able to see, and then I call in along with the sureties.
So who's getting out? What do they consider nonviolent? What is first? Sorry, there's two questions.
Yeah.
What is nonviolent considered?
I mean, it's broadly speaking, it's it's people who aren't charged with violent offenses that involve assaultive behavior or quote unquote violent behavior, right? So, but you have to understand that that's not really the cutoff or the criteria in terms of determining who's going to get or who's eligible for bail, right? Because I mean, there are a ton of like drug-related offenses, for example, that are by their nature are not violent, but they place the accused in a situation where they're in what's called a reverse onus, which essentially means they have to prove or show to the court why they should be released, as opposed to the other way around, right? So just because an offense is non-violent doesn't necessarily put you in a better position.
Okay. You don't have to answer this question that I'm going to ask you, but do you think race plays a part in who's being released?
Well, I always say anytime I represent a client, context matters. The person who's before you, and when I say before you, I mean the trier of fact. You have to take into account who you're dealing with. Whether you want to acknowledge it or not, justice isn't blind, right? I mean, there's certainly, all throughout the system, there are decisions or choices that can be made, right? So, for example, when the police interact with somebody, they have the discretion whether or not they choose to charge somebody. If they choose to charge somebody and the person comes before the courts, certainly a Crown attorney has that discretion as well in terms of whether or not they're going to continue with the prosecution. So, yeah, I mean, race is certainly something that plays a part, right? I mean, you can't with a straight face say that somebody's identity doesn't even on a subconscious level play some part at some point throughout the process. I'm not saying that all cops who deal with individuals are racist or they're working from a framework or a mentality where race is the sole issue. But I mean, at some point, when somebody's interacting with with a criminal justice participant, it's to suggest that a race may be a factor in how they're treated. I don't think is a crazy statement to make.
Okay. So now, with that being said,
Yep.
Who is getting out, or who do you find is getting out?
So I think since about mid-March, there have been maybe 24 cases reported and unreported that I've come across, and there's been a fairly wide spectrum of people who are being released. So, like for example, I've had some clients myself who are facing fairly serious, fairly violent charges who have been released on bail. But again, those clients tend to be released on more strict terms. So a house arrest, along with electronic monitoring. I'm sure Steve can touch on that a bit more.
Yeah.
But there are, also reading some of the cases, there have been some persons who have been, for example, released on their own bails, right? But again, the one case in particular that I'm thinking of, that's a situation in which the person had, very significant health issues. She was somebody who had a compromised immune system, and again, using the term nonviolent offender, the offenses that she was charged with were in fact nonviolent offenses. So they were mostly frauds and thefts. So there were also, I believe, if I'm not mistaken, there were addiction issues there as well. So so ultimately, she was released on a bail review, if I'm not mistaken, to John Howard Society. But I would imagine that would be a situation like that is not one that's going to necessarily play out all the time. It's really, but I think what we can take from the cases, or the vast majority of the cases that have come out, is that this COVID-19 pandemic is not a quote unquote get out of jail free card, but what it is something that has to be seriously considered, because I mean, as the health professionals and other advocates have stated already, it can have detrimental effects on people's health, right? I mean, it can kill people. We've seen it. We've seen that that's actually been the case. And I think it's also important to note that it's, certainly logic dictates that given how it spreads, or at least from what we know, it makes sense that the best, one of the best ways, at least until a vaccine is made available, is to ensure that people practice social distancing. The practical reality is that's very difficult to do in whether it's a provincial or federal institution. It's almost impossible to do it, right? So I think given that, the only logical or practical alternative, I'd say, is to release as many people as possible.
Question.
Yeah.
What is a solid what's a solid plan? What does a solid plan look like?
A solid plan will really depend on the facts of the case, right? So, I mean, you have to remember, at minimum, when it comes to bailing somebody out, a person's got to be at least 21, ideally no criminal record, no outstanding charges. They can't be a surety for anybody else at the same time, and they've got to be a Canadian citizen or a permanent resident. And there's also an expectation typically that they pledge a certain amount of money on a no deposit basis. So if you require somebody to bail you out, or a surety, that's typically that's at minimum what the courts expect. But then again, there are other factors that may require certain other conditions or certain other considerations when it comes to the bail. So, for example, if the person has a criminal record, if the person has a criminal record, and more specifically a history of breaches, so that especially breaches of bail or breaches of other court orders, so probation, breach of a peace bond, for example, like those are all things that the courts take into consideration. So if that's in fact the case, then you may have to tailor the plan to make it quote unquote stronger.
Okay. So with Ford announcing that they will begin to reopen,
right?
Is that going to affect the courts? So how's that working how does that work with corrections?
Well, I mean, I'd be very surprised if things went back to normal. And when I say back to normal, I mean where we're back, and the courts are up and running, in the next month or two. Because I mean, in fact, the statements were released on Monday and I believe yesterday on behalf of the Ontario Court of Justice and the Superior Court of Justice, and they both said that July 6th at the earliest is when trials will resume, and in the case of the Ontario Court of Justice, preliminary hearings as well. So at the very earliest, July 6th is the target date. I'd be very surprised if we got to a point where we're back up and running and having trials as of July 6th. I think the one thing that this pandemic has really forced the courts to do is reflect on how justice is quote unquote met out, and how in terms of how the process actually plays itself out, right? Because there have been calls for years, way before my time, to modernize the court system, and we're at a place now where that's the court's hands have been kind of forced, and really, I mean, the best we've been able to do up until now is, on a limited basis, have telephone bails, for example, right? So I mean, for us to get to a point now where things are up and running by July 6th, there's a lot more work that needs to be done in the background in terms of developing the proper infrastructure to see it through. Because I think what people have to remember too is there are so many trials and preliminary hearings and other applications that were postponed as of March 16th. So when things are up and running, the backlog is going to be, I mean, it was already bad before this. It's going to be even worse now, right?
Okay. Thank you. Are there any questions, Jafari?
Yes, there's a question here from Samuel Boykai. My apologies if I did not pronounce that correct. What measures are going to be taken to ensure that inmates receive adequate justice, being involuntarily subject to inhumane circumstance due to COVID-19?
I don't know that I can necessarily answer that question. I mean, other than, I mean, my role as an advocate will ensure, to the best of my abilities, that I'm able to certainly bring to light some of those concerns and some of those issues, the conditions that the clients are facing. So, for example, even before COVID-19, there was a push, say, over the last year and a half or 2 years, to have clients who have either been found guilty or who have entered guilty pleas receive enhanced credit because of harsh conditions at most notably the Toronto South, but also other institutions. And so, because as it stood prior to this real push, the most in terms of credit somebody could get would be for every day served, they get the equivalent of 1.5 days. But because of rather effective advocacy from a number of defense lawyers, judges have come around to the realization that that's just not good enough, right? Because the harsh conditions are, clearly they're systemic, they're ongoing, and because institutions like the Toronto South haven't really responded or listened to what the courts have said in terms of at what they expect at minimum in terms of housing persons at these institutions, it's resulted in enhanced credit. I imagine, I mean, it's hard to say at this point, but I imagine once we get a more clearer picture of what's happening in some of these institutions, some of those arguments will certainly be made more vigorously as a result of what may be taking place there. Because I think, for me personally, at this stage at least, the difficulty has been really trying to flush out some of those issues. Right? I mean, because my goal at the end of the day is to get as many people out on bail as I possibly can during this time. And when you find yourself in a situation, as has been the case, where every time you ask a question from somebody from the institution, and all you really receive is pushback, which only creates further difficulties. And for example, for me, it's resulted in, I don't get the answer I want. Okay, fine, no problem. I know right now that the courts aren't really up and running, but I also know that that if I need something in terms of finding out what's happening in terms of my client, the first thing I do is I just draft a subpoena. All right, you don't want to tell me what's happening? I'm gonna get my subpoena. I live 15 minutes from a courthouse. I drive down there. I go in. I get my subpoena and I serve it on them. And I mean, the one good thing about this in terms of trying to get some of that information is that once I get my subpoena, the old way would have been somebody from the institution would have to attend. They come before a judge, and the judge would release the subpoena, the contents of what I'd subpoenaed, and then we would take it from there in terms of whether or not that should be considered. Now, I serve the subpoena on the institution, and they just email me the whatever I've requested, and then I can take a look. I take a look, and then I determine whether or not it's actually beneficial. Does it answer the questions that I've asked? If it does, great, and then I'll make use of it whatever I choose to. If not, then I've gotten at least 3 or 4 subpoenas for a number of clients because I'm sometimes what I'm looking for isn't there. So you got to continue pushing and pressing, and hopefully I think that's really at this point the only way to adequately address some of these issues.
How long is it taking to get a bail hearing?
It depends again, and I say that because depending on the nature of the charges, the Crown might say, well, this requires a special bail hearing. And typically, special bail hearings these days, at least, are reserved for individuals who are facing, typically firearms charges, anything serious like that. So there's actually basically every courthouse now, at least in the GTA, has certain Crowns who are part of a guns and gangs task force, and all they do is run gun bails. But the problem with that is once somebody's charged with a firearms offense, with few exceptions over the last couple of years, the Crown's position has been, all right, well, it's a firearm charge, set a special bail. And then the problem with that is, you end up waiting at least a week, sometimes 10 days.
And are you seeing people get out with firearm charges with ankle monitors?
Yeah.
Okay.
Yeah.
Right.
Certainly, as I indicated earlier, Steve would be in a better position to speak on it than I. But certainly, electronic monitoring is something that definitely enhances a plan, right? If you look at some of the case law, they talk about it. It's one of those. It's almost like a perfect witness for the Crown or for the police should a breach take place, right? Because there's no emotions involved, right? I mean, that monitoring equipment, it does its job regardless of who it's dealing with, right? So certainly there are some benefits there.
Right. We want to thank you so much. I know there's a lot of questions, so we're just going to jump on to the next panelist and then come back to the questions.
All right. Thank you.
Thank you. Steve from Recovery Science.
I'm here. I had it on mute.
Hi, Steve. How are you?
I'm good. How are you?
I'm okay. Thank you. Can you introduce yourself, please?
Yes. So I'm a founding partner of the company, Recovery Science. We just passed our 10-year anniversary. And my day-to-day role, I'm the director of operations. So I basically run most of the company, the day-to-day operations, our interactions with court, testifying, our interactions with the police in terms of reporting. So our first involvement in criminal bail was in June 2010. We formed the company starting with alcohol monitoring. So we didn't even think our plan wasn't to be where we are now. So we had an alcohol bracelet. So if somebody consumed alcohol, we could detect that they drank alcohol. And so our involvement in criminal bail was in 2010. But that device also did house arrest, called radio frequency, not the GPS that we have now. So we were getting all these calls, not for alcohol, but for the radio frequency portion of it, for defense lawyers proposing house arrest as part of the plan of release on a bail hearing. So I started testifying in those cases, and it was very easy for the Crown to say, what happens when the person wearing the bracelet walks out the front door? And the answer was always, well, we don't know where they've gone because that's beyond the radio frequency. So in 2012, we decided to bring on GPS, and that's starting at that point was where we see the evolution of the impact of electronic monitoring on bail. So where we are today, where it's more or less widely accepted the Crowns will still contest the bail and try to poke holes in our monitoring. But compared to where we were that long ago, it's come a long way. So and then fast forwarding to COVID, how that's had an impact on our work and our business. Starting March 20th, we saw a significant increase in our cases. So normally we would monitor about 20 more people per month. So every month we'd add 20 new cases. And that's been pretty consistent over the last 2 years. But starting in March 20th, there was a concerted effort by the Criminal Lawyers Association for the defense lawyers in Ontario, primarily, to try to get their clients out, to bring on bail reviews, because all the trials were being postponed and all the courts were doing was bails. And so since March 20th, and ever since, pretty much every day, we've been flooded with calls from defense lawyers asking us how to add our monitoring to the plan of release.
Okay, and I do have to say that every defense lawyer that I've spoken to, they refer to you guys, to your company. So that speaks volumes. Question. So who are you seeing coming out with successful bail plans with a GPS monitor or a monitor, period?
So just because we're in Ontario, bail across Canada doesn't require a surety. I don't know if it's out of habit or how that became the norm, but in Ontario, most bails have sureties. Okay. And so it's kind of come to be accepted that electronic monitoring enhances a bail plan. But in the case law, there's a case called ANTIC, and it was very influential. And basically, everybody refers to ANTIC because it describes the latter principle. So that the court is not imposing, the court will only impose the least onerous condition outside of detention. And so the highest form, according to ANTIC, of the highest form of bail was a surety bail. So it's just become very accepted that sureties form the core of a bail, and electronic monitoring sort of just enhances it if needed. So even in cases where defense lawyers will call us to be part of the plan, people still get out on bail without the electronic monitoring because the court is that satisfied with the sureties. Where we come in is where the starting point at a bail hearing, the Crown says, do not let this person out because they're going to flee or they're going to commit further offenses, and we're at this very high level of risk. The court will then look at, well, what are the factors we can use to reduce this risk? So sureties being one of them, and good sureties that the Crown will cross-examine these sureties, and that might be enough to reduce the risk below that line, this hypothetical line. And that's where the monitoring is not required. Where the monitoring is required is where, even with good sureties, the level of risk is still over this line, and the court then says, based on a similar case with similar charges, similar criminal record, 1 year ago, whatever years ago, the court granted bail to this person. And so that sort of acts as precedent where the court can then rely on that case and say, I'm also going to be ordering the electronic monitoring. And then with the electronic monitoring and a good surety, that reduces the risk below the line, and then the court can then grant the bail.
So for the families who have loved ones with gun charges, is that something that the court usually looks into when it comes to the ankle monitors? Like, do you find that people with higher offenses would likely get it with the ankle monitor, get the bail, especially in this time?
So two answers. We typically get involved where it's an uphill climb, right? Nobody voluntarily wants to put electronic monitoring on the table because there's a cost to it, right? So lawyers are very good at looking out for their clients, and they'll call us and say, well, we'll see if my client can afford it, but or we'll call you sort of like as a last resort, right? So people will try not to propose the electronic monitoring unless they really have to. So because of that, we typically get involved where the charge is serious, right? So we've now monitored close to 1,000 bails across Canada in our history. We've monitored 46 murder bails. So the person that was charged with first or second degree murder. And then especially being around Toronto, a lot of gun charges. So a lot of gun charges, a lot of drug trafficking, that forms sort of the most common charge that we monitor. But all the way down to fraud. So all the way down to a breach of recognizance of a previous bail. So it doesn't have to be serious. It typically is serious when we get involved. And so during COVID, Adris talked about the approximately 24 reported cases. I think a lot of those cases were gun charges, trafficking. So just the sort of the typical representation of the types of cases that we monitor. So it did happen to have a lot of gun charges.
And do you have like any numbers of people that breach with a ankle monitor on?
We do. So this is where the monitoring is that we can present to the court is effective. Of the 1,000 cases that we've monitored, approximately 25 of those cases are what we call consent releases or releases on consent, where defense counsel and the Crown put their minds together and discussed a plan, and they presented it jointly to the court. So the Crown was on board with the release plan. 75% of the cases that we've monitored, the Crown contested the bail. So this is where on the gun task force, the Crowns routinely are just saying, no, we're contesting this bail. And they will advise the court, look, you can't release this person because the sureties didn't do their job as parents, and they don't know their kids well enough. They don't know what they were doing for work. Electronic monitoring doesn't work because the person could just cut the bracelet off and run off, and nothing prevents them from committing further offenses. So in those cases, you would expect, if the court did grant release to those people that the Crown contested bails on, we would have a very high number of breaches or violations. Right. Our violation rate is about 12%. So in all of our cases, it's actually less than 12%. It's probably under 10% now, where we detected the violation and we called the police. And so about a third of those are people that cut their braces off. They didn't all flee the country. So most of those people were arrested. Some people were impulsive. They got into an argument. They cut it off. And most of those people were arrested. So that's about a third. And then 2/3 are zone violations. So violations where the accused breached their house arrest condition. So they're supposed to be out with their surety or their parents, and they left on their own, or they entered a restricted area that the court said they could not enter. Okay. So given that about 700 bails were contested by the Crown, only 100 people violated their bail conditions. That's a very strong number to present to the court to say, this monitoring does something. And what it does is, the person wearing the bracelet, if they were not wearing the bracelet, they might take risks. So they might get a call from their friends at 3 a.m. and sneak out. Or if their mom catches them coming back in the house, they might say, don't call the police, even though you're the surety and you put money on the line on the bail. Don't call the police. You don't want to lose that money. But they know that if we're monitoring them, if they leave at 3 a.m, everybody's asleep, we will catch them and we'll call the police. And we've done this routinely so that the court has confidence in us that even though the person that's being monitored pays for the monitoring, we will act against their interests. So that establishes our credibility in the system.
And just to confirm to the people watching, this is for people who are awaiting trial and on bail, or is this for parole as well?
Nothing stops us from providing monitoring at any stage in the system. It just so happens that the demand is for bail. So that's just, we get a call, we'll provide the service, right? So, one distinction, for federal parole, there's a government program. So that's free. If you can get on that program, you apply for it. And if you do get the parole, they have ankle bracelets for it. If it's provincial parole, we can become involved, but I don't think we've ever had any cases for parole. We've been proposed a few times, but most of our cases are for pretrial.
And are you able to talk about your pricing?
Yes.
Okay.
So our pricing has not changed for 10 years. So the reason why we gained traction in the system was other companies were out there long before us. And their view was, look, we're the only game in town. If you need it, you're going to pay whatever price we put out there. So it was $1,000, $2,000, thousands of dollars a month. So we came along, three people formed the company, and we said, well, we're going to put the price at this number, even though we have one case, and we're going to lose money for years doing it. But we kept it at that number, and that allowed us for lawyers to present, to propose the monitoring, and us to have reported cases. So that number has stayed the same. It's $540 per month. What we did in 2020 was after years of hoping that there would be other agencies or government agencies to fund the monitoring, that never came to be. So in 2020, to make it more affordable, we introduced 2 lower levels of pricing. And so if a person is on legal aid, the price is $450 per month. And then if the person is on legal aid and the total amount pledged on the bail is $5,000 or less, we drop that fee to $360 per month.
Okay. And if they're not on legal aid, how much is it?
If they're not on legal aid, it's $540 per month.
Okay. Okay. And
And so I should also mention, so the government has never been involved in bail, but because of COVID, the government's program for conditional sentence, there's ankle braces for that. There's always been ankle braces for that. It's not GPS, it's radio frequency. So I think because of the pressure of COVID and having to decrease the jail population even further, they've made that program available for bail. So people should be aware of that. It's free. So when we get calls, I'll tell people that, look, go and try to get a free one if you can. There might be a wait and there's some longer procedure to get one. It's not GPS, so it doesn't tell where the person goes. So it might not be able to meet certain risk levels. But I tell people, go try to do that. And then if you can't get that, or you still need us because you need something more than the RF, then give us a call. So, but people should be aware that there is this program out there. There's only 90 bracelets out there at this time. And I know some of them have been taken already, but you should actually try to get some information on that.
okay. And if people want to get in contact with you, where can they reach you?
Our website is recoveryscience.ca, and there's an area on the website to ask us questions and give the information for us to contact the lawyer or the person that's contacting us. Or our phone number is 416-227-1400. And so what we do, so the difference of what we do as a company is 24/7, we respond right away. So if we get an email from a lawyer at any time, we make sure that there's no wait time, right? So that's why I'm always busy. I've been busy pretty much 12 to 15 hours a day since March 20th. That's because whenever there's a call, I provide a service where I meet the needs of that defense lawyer, whatever materials they need. If they need a letter from me, there's no fee for it. And then also if they need me to testify at the bail hearing, which I've done many, many times during these past 6 weeks over the phone or by video, I do that, and there's no charge for it as well.
Okay, great. Thank you so much. Is there anything else that you'd like to leave with the viewers?
Yeah, I think outside of the electronic monitoring, I've been part of the system. I've seen the criminal justice system from many different angles, including as a witness. So when I'm in the box and I get cross-examined by the Crown and I see inmates being brought into court, just a couple things I think I'd like to share, just having listened to what's happening tonight.
For sure.
COVID is terrible, right? It's definitely terrible, and it's some really bad stuff going on. And the level of care for the people that have the responsibility to show some care, it's not there. And it comes down to accountability, and it's really hard to get people to be accountable. So the energy can be there, but it's like who is going to say, this system should have been ready, this system should be fixed. It just seems like it's such a mountain to climb. That's just one thing. But even without COVID, I've always thought it's very sad where I think the mom described or the sister described people being in cells just waiting and not having anything to do. So I always just look at the one thing that I've seen in court is somebody being brought in from Toronto South to a courthouse, and they have a bail hearing that day. And what do they do all day? So they get brought in by a car, they're in the courthouse, they're sitting there all day just waiting for the name to be called, right? And then they finally have their bail hearing. And sometimes that bail hearing finishes that day. Sometimes, the judge will say, well, I need a week or two to think about this. So they go back, their bail hearing is done, and just because the judge needs to think about it, which is a proper procedure, that 2 weeks that everybody gets to go home and comes back in 2 weeks, that person applying for the bill, they go back to Toronto South and they're just sitting there for 2 weeks. So it's just always been very difficult for me to see. Like I've always asked, what do people do? What do people do in jail? Like what's the boredom level must be like so high, right? And it's just right. It's not right. So I think everybody has to be mindful of COVID's terrible, but just the system itself and getting in trouble with the law or getting, not really being in trouble and getting arrested and then finding yourself into the system. It's just such a thing to avoid, right? Because once you're in there, it's just a terrible, terrible place to be in. So COVID or no COVID, that just always had an impact on me. And then really the second thing is just the waves of people in jails and in the criminal justice system. So if you're in Brampton Courthouse, you look out in the window from the upper levels and you see a packed parking lot. You can never find parking there. And I remember years ago, I thought, well, this must die down, right? Like maybe something's happening this week. Week after week, month after month, it's just packed parking lot. And they've actually expanded the building, made it bigger, right? Expanded the parking lot, and it's still full every week in, week out. So it's just, on the level of what the criminal lawyers are doing, it's great. They're advocates, and they're getting, they're getting their clients out. But that's just on one level, right? So I don't know what the answer is, right? Just on an institutional level, it's just I'm glad you're doing what you're doing. I guess that's what I'm trying to say.
Thank you so much.
Sorry, I have a question from Richard Miller. I would like to know about offenders being charged with issues with the monitor failing as falling off of their legs.
Sorry.
So the question was, I would like to know about offenders being charged with having issues due to the monitor failing and falling off of their legs. That's the question.
So I guess the question is, do the monitors ever fail, and do they ever fall off of individuals' legs?
No, they don't fall off people's legs. We'd be in a lot of trouble if that happened, right? That's why we don't use GPS watches. We get asked about watches a lot. People want to wear watches,
right?
So the hands can be manipulated so that a watch could be slipped off. The foot is in the way. So when we put the bracelet on, we put it on at a certain fit, loose enough to be comfortable, but tight enough so that the foot's in the way and it can't be slipped off. So, and then so the second part of that question is technical issues. Sure, right? Sure, we encounter technical issues. We have feedback from the bracelets that let us know that it's functioning, so it's giving us GPS points. And then if we ever have any issues, we're aware of it. The person wouldn't be aware of it. We don't want them to be aware of it. It's rare that it would happen, but when it does happen, it's our responsibility to inspect the bracelet, get it fixed. So those happen.
Okay, thank you. We just have one more panelist, so if anyone has questions, write it on the board and we'll ask it at the end, just in case people have to leave. We want to thank you so much for sharing. And I just want to speak, Mr. Alawi, I just wanted to give you the opportunity to leave your contact information as well I forgot to ask you. If someone wants to contact you, can you leave your information, please?
Yeah, I certainly can. By phone, it's 416-551-4449. By email, it's my first name, A-Y, D as in David, E-R-U, S as in Sam, at ALAWILAW.ca.
Great, thank you. If they want to look you up online, what's the name of your firm?
Alawi Law. So I'll leave my details in the chat.
Great, thank you. So we'll come back to more questions at the end. I just want to introduce our last panelist, Nancy. I can't pronounce your last name. I'm so sorry.
It's okay. It's French. Charbonneau. So the EAU is an O.
Okay.
The Charbonneau. It's anglicized, but it's French Canadian.
Well, thank you so much for joining us today.
You're more than welcome. Thank you for having me.
Can you introduce yourself, please?
Sure. So I am a parole lawyer. I've been working as a parole lawyer for 15 years. And I talked to, is it Zia or Zaya?
Either one is fine.
Leave it a mystery.
My granddaughter calls me Zaya, so we could go with that.
Zaya.
Grandma Zaya?
What do I remember? Yeah, so I don't even know why you called me recently, but I can't remember now. But we chatted and she asked me to participate and to share with all of you how parole works, both in the federal and provincial system. I do mostly federal parole, and I work mostly with inmates within a 2-hour radius of Toronto. So most of my clients are at Beaver Creek or Warkworth, but I'm connected to the prison lawyers in Kingston as well. I'm a member of the Canadian Prison Law Association, so I'm connected with prison lawyers across the country, and I try to keep abreast of what's going on. And regarding COVID-19, I'm going to try to talk a little bit about that today as well. But I know Zaya, so did I get it right? She asked me to talk about how I became a prison lawyer. And when I was in law school, I ended up writing a paper on the right of inmates to vote. And then I articled with the Attorney General and did some work with the sister ministry, which is the Ministry of Community Safety and Correctional Services. And I was just very interested in the whole world of corrections. And then I did work as a corrections policy advisor for a year after I was called to the bar. And I did find the ministry very dysfunctional, and felt that I would be more use actually practicing. And so so I started my practice with the intention of practicing prison law, and now do mostly parole. I also do some child protection, so I assist parents when the kids are apprehended by the Children's Aid Society, which is completely unrelated, although there ends up being some crossover. Sometimes I have, of course, clients who have been through the foster system or clients whose kids are in foster care. So that's that.
Okay. Questions. So what changes have you found with COVID-19 when it comes in regards to parole?
So in the federal system, the big change is that when an offender is granted parole, they're more likely to be granted day parole to their home instead of a halfway house, or full parole home rather than day parole to a halfway house. So previously it was extraordinarily rare that a federal offender would be granted parole to their home as their initial parole grant. Like in 15 years as a parole lawyer, I've had maybe 5 clients granted full parole. That's how rare it is. Okay. But I had one last week. You know, it's just something that they're doing now. I have for my clients this month, I have a couple that are supported to go home. So that's big. And then in terms of provincial, the provincial system, they have released 32% of offenders in the provincial system. They have gotten rid of a lot of people. They did that by, and I've only read about this, but anybody who had intermittent sentence, they now just have to check in, and they don't have to actually serve any time at all. And otherwise, for anyone who has a non-violent offense who has less than 30 days left on their sentence, they're being released on a TAP, so the temporary absence program. So that's a big difference. Okay. Legal Aid is now funding the temporary absences. So okay, so in the federal system, unescorted temporary absences are a type of absence that can be granted for medical reasons. And the Queen's Prison Law Clinic, which is a legal aid clinic in Kingston, had brought an application. They were trying to get an inmate who had cancer and only 4 months left out on a UTA. And in the end, the warden authorized the UTA without the litigation coming to fruition. So we didn't, there was no precedent, of course. And the idea was that more inmates would be getting out on UTAs, but that hasn't happened yet. So what the Correctional Service is saying is that they are going to be looking at people who have less than 6 months to their statutory release date, who do have health problems. But again, I don't think it's happening yet.
What?
Zaya, you wanted me to talk a little bit generally about parole. Maybe I should do that, like kind of give the definitions.
Definitely.
Because it is a little bit complicated. Okay, so most people know that most people get out at 2/3, which is statutory release. So whether they're provincially or federally incarcerated, and so you already covered this, but if they're serving 2 years less a day, they're in a provincial institution, and if they're serving 2 years or more, they're in federal custody. So parole eligibility is a little bit different in the provincial and federal systems, and it manifests completely differently. So in the provincial system, and 96% of offenders are in provincial custody, parole eligibility is at 1/3, okay? And if an offender applies for, or they don't actually have to apply, but if they're being considered for parole, their hearing is exactly 2 weeks before that 1/3 date, and they get out at 1/3, okay? So, you asked me, who gets parole. So for offenders in the provincial system who have a sentence of 6 months or more, they are automatically considered for parole unless they waive their right to parole. So I would definitely say to people who have loved ones who are incarcerated, or people who are incarcerated, do not waive your right to your hearing, first and foremost, unless, you know yourself, and if you're really, really, a troublemaker, not following the rules, you definitely know you're not going to get it, okay, fine. But the first step, of course, is to not waive your right. Don't be pressured into waiving your right if you feel that, there's any merit to your case at all. If your sentence is less than 6 months, okay, then it is still possible to apply for parole, and you will be considered 2 weeks before your eligibility, like with the offender serving slightly longer sentences. So previous to the pandemic, the parole board, the Ontario Parole Board, wanted to see, do you have a place to live, of course? Do you have a plan for some kind of treatment? It could be it could be any kind of, group treatment or individual counseling, or even, John Howard has people who work in their office who will often write a letter saying, I'm willing to provide this guy counseling, once a week or once every 2 weeks, whatever it is. And third, a plan for work or school. So obviously with COVID-19, it's, much less likely that a person would have a plan for work or school because the schools are shut down and, many, many people are not working. So I'm imagining that the Ontario Parole Board would mostly be looking at whether the person has a place to live. And it would never hurt to set up some kind of counseling. Like most organizations are providing telephone counseling, even with COVID-19. So whatever it is, if you have the funds to hire a psychologist or a social worker to do counseling one-on-one, if whatever type of problem the person has. So for a sex offender, specialized sex offender counseling would be helpful. If it was drug addiction, then obviously some sort of drug treatment program. Get in touch with CAMH. Get on the internet, find out what service providers are available, and have some kind of plan for treatment. That really, really, really helps your parole application. Okay, so there's that. And in terms of also the procedure, each institution, each provincial correctional facility has a person called the Institutional Liaison Officer, ILO. And the ILO is the person who coordinates parole. So any inmate can put in an inmate request to speak to the ILO. Usually the ILOs, make the rounds, but if an inmate has any questions, that person would be able to help them. Okay, so now the next level is TAP, Temporary Absence Program, which your earlier panelist mentioned. A TAP, a temporary absence, can theoretically be granted at any time for a provincially incarcerated offender. Sounds crazy, I know. So, as I was saying, offenders have been released on TAPs because of COVID-19, but mostly offenders who only had 30 days to their statutory release date or parole eligibility. But if you have a family member who is elderly or vulnerable to COVID-19 because they have a pre-existing condition, whichever it is, then on that basis, an application can be made for TAP. Another very interesting new thing is that legal aid is funding TAP applications, okay? So if you want assistance for your loved one or people calling in from custody, from provincial custody, there is funding for that. And I know 2 lawyers who are doing a lot of the TAP work. Well, Simon Boris in Kingston is doing it, and Jeff Ryback, R-Y-B-A-K. He does provincial parole, so like mostly provincial parole. So he would be a person that I think you could approach. And like legal aid really got on the ball, and they've actually created an application where the lawyer can apply for funding using a form. So the inmate doesn't even have to call legal aid. They can just call the lawyer, and the lawyer can help with that. I'd be willing to help with that as well, but I haven't been doing it so far. So you might be better off calling someone who's doing more of it. Like I said, I do mostly federal parole. Okay, so also legal aid does fund provincial parole. These certificates are only 5 hours, so you're not gonna get tons and tons and tons of help from a lawyer, but you're going to get a little bit of help. The other change with COVID-19 is that the Ontario Parole Board is doing a lot of paper decisions, and they're also doing hearings by teleconference, whereas previously they would be for any parole matter, they would be having an in-person hearing, the lawyer would appear in person, etc. I want to also emphasize, oh yeah, do you have a question?
I have a question about that. So parole hearings,
yeah,
what here there's only one person on the video call now. So are lawyers still able to be present, and are community members still able to be present?
So the lawyers are participating by telephone, okay. And I know with federal parole, support observers and victim observers are not allowed to be present. However, so I'm assuming with provincial parole, the parole support person would also be participating by telephone. They do have to identify a parole support person.
Speaking about federal, how is it with federal?
So with federal right now, there was the Muzo hearing last week, the family really advocated to be involved. So for the first time, victim observers were allowed to participate. So now it is official that victim observers can participate by telephone with federal parole hearings. However, family observers have not yet been allowed to participate, which is not fair, but that's what's happening right now. I am doing federal parole hearings over the phone. They are both video hearings, but lawyers are participating over the phone. So it's kind of weird, but that's what's happening. Okay?
Okay.
So should I move on to federal parole?
Yep.
Okay, so federal parole, totally different ball of wax. So, day parole to a halfway house is technically available 6 months before 1/3 of the sentence. Okay, so it's very early in some cases. For example, for a person, serving 2 years, they do have to serve a minimum of 6 months. So that person would be eligible at 6 months, but they're eligible. Inmates serving life sentences are eligible 3 years before they're 1/3. Sorry, not 1/3. Sorry, 3 months before they're. Sorry, I'm so sorry. I misspoke. 3 years before their parole eligibility. So let's say the sentence is life 15, life without parole eligibility for 15 years. They'd be eligible for day parole 3 years before that. Life 25, 3 years before that, they can go to a halfway house. However, what everyone has to understand about parole eligibility in the federal system is that the eligibility date means very, very little. The eligibility date is when you're technically eligible, but hardly anybody actually gets their parole at their eligibility date. It depends on many, many factors, but really at the end of the day, the parole officer will tell the offender, okay, you've completed your correctional plan. We feel your risk is manageable. We want you to apply for parole. You could have an 8-year sentence and get day parole 6 months before your statutory release date. So 6 months before your 2/3. So anytime between 6 months before 1/3 and 2/3, a person could get day parole. And again, they want them to do day parole usually for 6 months before they do full parole, which is home. For offenders serving life sentences or very long sentences, they often have to do more than one period of day parole. So it could be 18 months or even 2 years on day parole, granted at 6-month intervals, until they've saved a little money and gotten really reintegrated into society. So both in the federal and provincial systems, the people who get parole are
real quick. Sorry to cut you. What about right now with COVID-19? I just want to focus on federal.
Yeah.
Right now with COVID-19, with the pandemic, who's typically getting parole?
So I would say that not much has changed so far with the pandemic, except that I know the parole officers have been directed to identify offenders who would be good candidates for full parole, meaning home. Okay, and also the other thing that has changed is that for offenders that were already on day parole, already in the halfway houses, they also were evaluated, and many were granted full parole early. So they didn't do the full 6 months. And that was because the halfway houses reduced their populations in order to, allow for social distancing. So they reduced their populations by anywhere from, 25, 30% to 50%. Like I heard that the Brampton Halfway House, St. Leonard's Peel reduced their population by 50%. Toronto, Salvation Army halfway houses reduced their population by 25 or 30%. And once they got their numbers down, they started taking guys again, because everyone was sort of freaking out. Like, are the halfway houses taking people? The halfway houses are still taking people. I've talked to a few of them, and they were all taking people. So that's not different. Whether it's to get parole or to get a temporary absence or, in federal or provincial custody, it is imperative that the inmates do not break any of the rules. So if they have a misconduct or a disciplinary charge, that is really, really going to hurt their chances of parole for a long time. So like in federal custody, it's minimum 6 months to a year that a guy will have to defer his parole or delay his parole if he has, any incident or charge. So, that's not like 100% set in stone. There are cases where there is some kind of minor incident and someone still gets parole, but their case is always reassessed if there's an incident or a charge, and often they lose support of the halfway house and their parole officer, which really hurts their parole. So they also have to, like in the federal system, they will have to complete their programming if they qualify for core programming. It's also extraordinarily helpful if they do, as many volunteer programs as possible. Now, everything's on hold right now. All of the volunteer programs are on hold. Even the core programming is on hold. This is actually another big thing that's really affecting people. So all core programming stopped in the federal system. And for a guy where he has to complete his program before he gets parole, this is a huge problem. Again, it just depends on the case. I think that with some of them, they'll be able to get parole without completing their program because of COVID-19. And with others, if they're assessed as having a very high risk of reoffending, it's going to hurt their parole. Like, they're not going to let them out without a program.
We have a few questions. What type of counseling, community counseling for gun charges would be recommended? So earlier you mentioned if someone has a sexual charge that they could get a community organization. So what about gun charges?
So it would be, criminal thinking. So I don't know, something to address their, decision making.
So I would hope that Think Twice would be a part of that, because we do on that.
Yeah. Do you do counseling? Oh, that's great.
Yeah.
So exactly. So, any kind of counseling, any kind of, involvement in any kind of group would be, that's what the board wants to see. What are you going to do during your release that will reduce, your risk of reoffending on a long-term basis? What plan do you have to address your risk factors, to address your problems, right? So like I said, John Howard also, they do have counselors that provide exactly that type of counseling. And it might maybe like anger management or something like that. I don't know.
Another question is, what is the success rate of federal offenders getting parole on a gun charge?
So I don't have those numbers in front of me, but I have tons of clients who get parole with gun charges. I mean, they usually have longer sentences, minimum 4 years, often longer, depending on their record. So, I do parole hearings for guys with gun charges all the time. Of course, if they're up for parole, it's because they've, taken their incarceration seriously, and they're not part of the subculture. They're not involved in any violence, while they're incarcerated. They're not involved in, any contraband. No drugs, no alcohol, and aren't involved in any incidents. Like, all these reports, like what they want to see is he keeps to himself, he's respectful, with, program facilitators, other offenders, officers. It's all about their attitude, right?
And also, do federal offenders get parole on gun charges, like day parole, full day parole as well? Do you see that as well?
Yeah. So day parole is, I know that this language is foreign to everyone, but day parole is released to a halfway house. So Correctional Service Canada has contracts with halfway houses all over Canada, but in all of the major cities, there are halfway houses. So Ottawa, Toronto, Brampton, Peterborough, Hamilton, all the way up to Sudbury, Barrie, Kitchener, St. Catharines, Brantford. Like they're all over. Even Cornerstone in Oshawa, there's one there. Like so all over the province are halfway houses. Now, and again, I want to make sure I'm always making that distinction. There are almost no halfway houses for provincially incarcerated inmates. So it's really inmates serving 2 years or more that go to halfway houses. But yeah, so I forget exactly what your question was. I think I answered it, but.
Yeah, no, that's good. Also, how does a federal inmate apply for temporary absent release?
A federal inmate? Okay. So they would have to do it through their parole officer. Every federal inmate has a parole officer. And I would put in an inmate request that they would like to apply for a UTA. So if they fell into that category, again, where they were, certainly if they were elderly or, having some sort of pre-existing condition. And according to what CSC is saying, they are looking at granting these for people who have less than 6 months to go. So yeah, through the parole officer.
Okay, and I'm going to ask you one more question and then we'll wrap it up, because for the sake of time, I think people have to
go to bed.
Yeah. Is accelerated parole release still in effect in the federal system?
No. Okay. There are a few cases, I guess, that may be trickling through, but APR was abolished, oh gosh, many years ago now, by our dear friend Stephen Harper. Sorry. Then there was a whole bunch of litigation where they allowed it for, so APR used to be release at 1/6 for first-time federal offenders convicted of non-violent offenses. Okay, but no, it has been abolished. Like I said, there are a few. I had one. I think I had a guy. Gosh, I'm just trying to think of how it worked. Whose case? I think he was back on a parole suspension. So there are a few guys who are out on APR still. But I think at this point, all of the cases have been, assessed and granted, because it's been so many years since APR was abolished. So APR was a one chance release. So if someone comes back, if they're out on parole, because you have to understand with federal offenders, they could be out on parole for years and years and years and years and years. But if a guy comes back on a suspension, he doesn't get another chance with that under that same criteria. The criteria for release on parole is your risk not undue, and will you use your release to work towards your reintegration? So is your risk manageable, and will you use your release to work towards your reintegration? So they would be, if they did have enough time left on their sentence that they were eligible for another parole consideration, it would be under the regular criteria, not simply this non-violent criteria.
Okay.
Okay, I have one last question here. Can a federal inmate still apply for early parole even if he has not completed his mandatory program due to COVID? What are the chances of success?
Yeah, there's the $1 million question. So I actually have clients again this month where their programs were cut off. So we'll see how it goes. The big thing is your parole officer still supporting you, and you have a halfway house still supporting you. So if your parole officer is still supporting you, even though you weren't able to complete your program, and you have a halfway house that's still supporting you, awesome. If you don't, your chances are always super, super low. That's just how the federal system works. Like, it's all about, taking the direction of your parole officer, and it's rare. It's not like impossible, but it's rare. I don't think it's fair to deny people parole when it's not their fault that they haven't been able to complete their program. But I think it just depends again on that particular inmate and his risk. If if the board finds that his risk is manageable, then that's the board's prerogative to grant parole.
Well, thank you so much. And if you could leave your information in case anyone wants to contact you.
Sure, it's Nancy Charbonneau, CHARBONNEAU. And my landline is 416-850-9983. And my mobile is 416-889-2506. And my website is nancycharbonneau.com. And I think that's it.
Great. Very last question. Would you recommend parole for federal offenders to get a lawyer or not?
Oh, wow. Federal, 100%. Why not? They have plenty of time to prepare for their hearing. Their parole lawyer will make sure they're prepared for their hearing. They'll, give them advice with all these decisions along the way. Provincial, it's actually very rare that a provincially incarcerated inmate has a lawyer. I think since this guy, Jeff Ryback, started his practice, he's the only one who does it as, being the majority of his work. I do, like I said, I do a little bit of provincial parole, and the board always has their backup, whereas in federal parole, the board is very accustomed to dealing with lawyers. About 50% of inmates have lawyers, and legal aid funds parole. So both provincially and federally, legal aid funds it. I think, Via, you wanted me to talk about finding a parole lawyer. When the inmate applies for legal aid will give them a list of lawyers, and the parole lawyers, I always say we have a very strong panel of parole lawyers, because it's all people who want to be doing this type of work. It's a very, very small panel. There are maybe like 12 or 15 parole lawyers in Ontario. So yeah, I mean, I don't know, it's what I do, so I'm a little bit biased, but I definitely, my clients are very, very grateful for the support. So I don't see why you would hesitate if it's funded by legal aid.
Well, thank you so much to all the panelists. We appreciate you for taking out your time and answering questions. If anyone else has any more questions, please feel free to message me on Instagram, and I will relay your message to the appropriate professionals, and Wes is gonna take it away.
Yes, so I discussed earlier a giveaway. We have a $50 gift card. So to qualify, we have a petition on our Instagram page where we're trying to raise awareness for prevention and sanitation for inmates and correctional staff. So to win, you have to sign the petition, take a picture, upload it to your Instagram, and tag our page, Think Twice International.
Wait, Wes, can I change that?
Sure, go ahead.
Can we have the giveaway to the person who fills out the survey at the end? Is the poll up, Jafari?
It's not.
Oh, forget it. Wes, tell them what they're doing again.
All right, so the petition that's on our Instagram page, just sign that, take a picture, upload it to your Instagram, and tag our Instagram page at Think Twice International. 2WICE twice. INTL. Zia?
Sorry, tired everyone. So we're gonna close. We'll see you next week. We won't have a panel this big next week. It'll be 2 people. But it'll be really thorough. So I want to thank you all for coming out. Make sure you keep up to date. We'll have this on the IG. We'll also have it on YouTube. We will post the questions and the answers to the IG if anyone else has additional questions. I intended to have a feedback form, so if you don't mind, just leave a message, any feedback in the messages. So whether it was informative, you'd like to hear this person or someone else, or if you'd like to speak yourself, leave a message and make sure that you contact me. The email's on there, Think Twice, or you can hit us up on Instagram. And yeah, that's about it. Thank you so much. I am tired, so I can't talk anymore. But please leave those messages. That is our feedback form tonight. Other than that, take care and be safe.
Yeah. Let's talk about freedom for a minute, man. Gotta save myself. Ain't nobody ever change me. Can't believe the system try to blame me. Ain't nobody ever change me. I know what I gotta do to save me. Ain't nobody ever change me. I can't believe the system try to blame me. Ain't nobody ever change me. I know what I gotta do to save me. I'm getting tired of the food and the milk cards. Tired of steel bars. How many times I gotta catch a street charge? I'm taking this time to gather my thoughts. Instead of starting frontin' in the yard, acting like I'm hard. Plus the guards don't give me no chance. There ain't no mercy shown.